You're much more handsome than I. Just reminds me of that for screen. Welcome to this event by the Federalist Society, selecting the next justice of the Supreme Court, Talk by the Legends. We're deeply honored to have you all.
Myths. Huh? There are more myths than legends.
We're deeply honored to have all of you here. We have with us today Professor Josh Blackman, Mr. Ed Whelan, and commentary from our own Professor Bertrall Ross. We're so grateful to Gabby Gonzalez and Martin Salvucci for their outstanding leadership with this event. The Federalist Society is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Professor Blackman is an associate professor of law at the South Texas College of Law. He specializes in constitutional law, the US Supreme Court, and the intersection of law and technology. He's the author of the critically acclaimed Unprecedented, The Constitutional Challenge to Obamacare. He's also the author of the article Selecting the Next Justice with Randy Barnett. Very fun fact, Professor Blackman was selected by Forbes magazine for the 30 Under 30 in Law and Policy. He has testified before the House Judiciary Committee on the constitutionality of executive action on immigration. He clerked for the Honorable Judge Boggs on the Sixth Circuit and for Judge Gibson on the District Court for the Western District of Pennsylvania. He's a graduate of the George Mason College of School of Law. Ed Whelan is the president of the Ethics and Public Policy Center. He directs EBPC's program on the Constitution, the courts, and culture. His areas of expertise include constitutional law and the judicial confirmation process. Mr. Whelan, a lawyer and a former law clerk to Justice Scalia, has served in positions of responsibility in all three branches of the federal government. We are also pleased that Mr. Whelan, as a former Wallace clerk, Judge Wallace clerk, could have been here yesterday for the inaugural lecture. We're also very honored to have commentary from our own Professor Bertrall Ross. Professor Ross's research interests are driven by a normative concern about democratic responsiveness and a methodological approach that integrates political theory and empirical social science into discussions of legal doctrine. Prior to joining the Berkeley law community, Professor Ross was the Kellis Parker Academic Fellow at Columbia. He clerked for Judge Nelson of the Ninth Circuit and Judge Myron Thompson of the Middle District of Alabama. He received his JD from Yale and has an MSc from the LSE. His BA is from the University of Colorado at Boulder. So I will give you our legends, not myths.
All right. All right. Thank you so much to Berkeley Federal Society. I'm glad. I think we've actually, with John, Ed, and myself, we've tripled the number of conservatives in the building. But we will do well. Our topic for today is perhaps one of the most important things we're thinking about. What should the next president think about when appointing a justice? The Chief Justice will soon inaugurate a new president. And when that happens, we're going to have a lot of old justices. The notorious RBG will be 83. Justice Scalia, Ed's former boss, will be 81. Justice Kennedy, 81. And even Justice Breyer will be 78. We will have 4 justices pushing the age when justices often no longer serve. So what I want to talk about today is what lessons can we learn from the past nominations, from the nominations in the Burger Court, the Rehnquist Court, and the Roberts Court. How have the past 7 presidents made their decisions, and what can we learn from them? So in this graphic, I list the past 16 justices that have been appointed, starting with Warren Burger all the way through Elena Kagan. And if I can be so crude, I'll divide them up based on the presidents that appointed them. Okay, you have 4 from Clinton, and you have 12 from the rest of the Republican presidents, right? So if you were to just look at this graphic and think, damn, we must have a conservative Supreme Court, right? Conservatives are going to win everything, right? But the actual makeup of the past 16 justices looks more like this. Whoa, let me do it again. You might have missed it. Ready? 1, like the eye doctor. 1, 2, 1, 2, right? Many of the justices who have been appointed haven't quite lived up to their expectations, so to speak. And even those that have are often somewhere in the middle. And there's a question mark on one of them. We'll talk about him later. So the thrust of my discussion is based on an article I wrote with Professor Randy Barnett in the Weekly Standard called Selecting the Next Justice. And our goal was to identify 5 principles, 5 lessons that can be gleaned of how the next president should appoint justice. So the first lesson, and this is a lesson which we should internalize, a bruising confirmation battle is worth the political capital for a lifetime appointment. For long after a president is gone, we still have their justices. And Exhibit A to teach us this is this man, a fine man who passed away a few years ago, Robert Bork. President Reagan nominated Robert Bork to the U.S. Supreme Court. He was a D.C. Circuit judge. And his hearing didn't go so well for him. You had people like Ted Kennedy and Joe Biden basically destroy Bork's character, and they impugned him in the worst terms imaginable. Maybe Ed can talk more about this later. It was a pretty brutal affair. Bork was not confirmed. Take 2. President Reagan nominated another judge from the D.C. Circuit, a guy named Doug Ginsburg. He was my professor at George Mason, also a really, really brilliant legal theorist. They always have the picture of them smiling in the Oval Office. It turned out that Doug Ginsburg had done some marijuana with some students, something stupid like this, right? Today, it's legal, go to Berkeley, buy some pot. Back then, this was a big deal. So President Reagan basically yanked, or he, maybe I had no details, but Ginsburg never quite made it through. Take 3. Here we have a picture of Ronald Reagan standing with a Sacramento Republican by the name of Anthony Kennedy. In the background, you see Attorney General Meese there. Why was Kennedy picked? They'd already lost one from Bork. They lost another with Ginsburg. Kennedy was viewed as maybe someone more moderate who wouldn't be so hard to sail through. And indeed, Biden and Kennedy, they put up a little bit of a fuss, but his confirmation hearing wasn't that bad. He was confirmed. Perhaps the first note of alarm was that Lawrence Tribe basically endorsed Anthony Kennedy and said, yeah, this guy's going to be good. Tribe is now taking credit for a burgleful on those grounds. So Kennedy was sworn in. 25 years later, we are still living with a decision of not having Robert Bork or Douglas Ginsburg on the Supreme Court, but having Anthony Kennedy. I don't need to bore you with his decisions because they're all the cases you read about in your casebook. He has all the majority decisions in every big 5-4 case. A couple years later, this man, William Brennan, the lion, right, had to step down. He could not live long enough to see a Democratic administration. I'm sure he would have. If he could have, he would have. He could not. Biden and Kennedy realized that this could make the entire Supreme Court. If H.W. Bush could replace a man like William Brennan with a liberal with a conservative nominee, it would alter the entire balance of the court. So here we have Bush's chief of staff, John Sununu, talking with President Bush, and this is the stuff of Washington legends. They hatched a strategy. What do we need? A stealth candidate. A stealth candidate. Someone who will not occasion a lot of controversy. And who they come up with? This guy with the sideburns, David Hackett Souter, right? A judge from New Hampshire, was on the New Hampshire Supreme Court for a number of years, was on the First Circuit for about 5 minutes. And Souter was viewed as someone who was a rock-solid conservative. He didn't have many opinions demonstrating that, but Sununu, this guy's good. And, oh, by the way, Sununu and Rudman and Boyd and Gray and others said, this guy will sail through. And here we have H.W. Bush introducing Souter, saying, this is going to be the guy. And then Time Magazine asks, who is this David Souter guy? Who is this guy, right? What do we know about him? Biden was like, oh, they got to be kidding me, right? This is so good. I mean, they put up a little bit of a fuss about Souter, but, he wasn't Bork. He didn't have the track record of Robert Bork or Doug Ginsburg, okay? The next nomination that came up, Thurgood Marshall, right? The great Thurgood Marshall. When this nomination came up, there was going to be a massive political fight, the first African-American justice. And then President Bush 41 nominated the boss of Mr. Yu, a man named Clarence Thomas, to the Supreme Court. Thomas had been a long time head of the EEOC. He had been a judge in the D.C. Circuit for about 5 minutes, as he often likes to joke, and Bush appointed him. Maybe John can talk about this later, but I don't know if the Bush administration quite knew what they were getting themselves into with the Clarence Thomas nomination. Joe's all smiles here. He always is all smiles. But the Thomas confirmation hearing became quite brutal in a number of respects. And actually, there's a movie coming out with the Kerry Washington about the Anita Hill story, in which you can read about this later. But effectively, the story came out with Anita Hill, and it nearly derailed Thomas's nomination. It was a massive, bloody political fight. Ultimately, Justice Thomas eked through. John, I remember the confirmation, but it was pretty close. Thanks, Ed Encyclopedia. 52-48. It was awfully close. And he just eked it through. And by the way, Justice Byron White was swearing him in and not the chief. I think the chief was out that day for some reason or the other. Okay? So then we fast forward, right? We have all the justices. I'm going to skip the Clinton and the Ginsburg nominations because Democrats don't have this problem. Only Republicans have this problem of making bad decisions. For the most part, they don't have to worry about these things. So the next nomination, we'll come back to the chief in a minute, but the next nomination came up in very short sequence. Chief Justice Rehnquist passed away, and Justice O'Connor retired. O'Connor actually retired first, but due to the timing, you had these two nominations open in very short order. And President George W. Bush nominated this person, Harriet Miers, his White House counsel, or not the counsel, but one of his White House attorneys, to be the next Justice of the United States, replace Justice O'Connor. Needless to say, this decision was ridiculed by many of the right, saying, "Who is this person? Right? What do we know about her? What's her background in constitutional law? What do we know about this person?" One of the first telltale signs something was amiss was that Chuck Schumer and Harry Reid basically said, "Yeah, we support her. Right? We're not going to block Harriet Miers' the Supreme Court." They think, "Wow, this is awesome. What a great nomination." Harriet Miers bombed. This slate had this Harriet Miers meter back in the time. As she met with members of Congress, even Republicans said, "Okay, this is not going to work." A lot of people on the right, bloggers and otherwise, said, we can't screw this up. We can't get another, Justice Souter. We can't mess this up again. So that led, of course, to Justice Alito being put in the Supreme Court. Okay. So what does this mean going forward? So one thing I want to discuss is the nuclear option. So traditionally, the threshold for getting a vote on a Supreme Court justice, or on a circuit justice, was 60 votes. Recently, Senator Harry Reid decided to do away with that. He said no more filibuster for circuit judge nominations and other executive branch appointments. But there's still a filibuster for the Supreme Court. So the first point I want to make is that will not last. The second the Democrats need to appoint a justice and they don't have 60 votes, that filibuster is gone. I can't imagine. Republicans may stand by precedent, but that's going to be gone. The nuclear option's here. Everyone opposes it when they're in the minority. When they're in the majority. But when the next Supreme Court nomination comes up, the magic number is now 50. Okay. And why does it matter that the magic number will be now 50 and not 60? Because you don't need as many moderates to peel off. You can actually appoint a justice who's closer to the polls rather than in the middle. And Harry Reid will perhaps reap the benefits, even though he's no longer in the Senate. So one aspect I want to talk about is what happens if you don't get to 60 votes. A president nominates someone, and he can't get anyone through. Right? The party in the minority blocks whoever they appoint. One thing to keep in mind is that there's a distinct possibility that there may be an empty seat in the Supreme Court. We can thank Clint Eastwood for that, right? Imagine a Republican president with a Democratic Senate, and the Democrats say, "We're not going to confirm anyone." Or a Democratic president and a Republican Senate saying, "We're not going to confirm anyone. We're going to wait till the next election, see what happens." So prepare yourself. There actually may be a vacancy in the Supreme Court. This actually happens in New Jersey and some other states, and we can talk about that later, but there's actually a distinct possibility we'll have an empty seat in the Supreme Court if the parties can't agree. I don't know which way this cuts. So that's the first lesson, right? These confirmation fights are worth it, even if it yields an empty seat. The second lesson that I want to draw involves paper trails. And it's often said that the perfect Supreme Court justice has no paper trail, right? There's nothing you can ding them on. I could not disagree more. We do not want blank slates on the Supreme Court. We do not want a ship just drifting in the water without a mast, going wherever the tide takes it. We don't want John Roberts. Okay? The Chief Justice, and this is a cartoon from 2004 when he was first, or 2004 or 5, was actually viewed as a stealth justice, and that was considered a plus. That we don't really know what he thinks. I mean, I'm at a federal society meeting. I'm a dues-paying member. I think Ed's a dues-paying member. John is a dues-paying member. John Roberts, we thought he was, but he claimed he was never a dues-paying member of the Federal Society. And then when it turns out he goes on a membership list, he's like, oh, my law firm paid for it, right? He, at every juncture, avoided taking controversial positions. Even his closest friend said, we never really knew what he thought, okay? No more, no mas. We don't need this. I will also put in that lump Justice Kagan, who, though she was a law professor, never really wrote anything of any merit or any controversiality. She had one article on free speech, something else on administrative law, but she played it safe. She wanted to be a justice also, and she did it, right? She was also dubbed as a stealth nominee, okay? We don't need what I call the little supremes, these people who want to be justice forever and keep their ships in perfect order and never do anything to make anyone upset. We want people with character, with a backbone, with fortitude of actually taking positions. This is actually Kagan's from her high school yearbook, Just Up Like a Justice. And she has a Felix Frankfurter quote in her high school yearbook, which I love. This is also Sam Alito's Princeton yearbook, where he said, Sam intends to go to law school and eventually to warm a seat in the Supreme Court. Funny how these things turn out. If you ever see that video of Ted Cruz saying he wants to be president, it's floating around on YouTube as well. So I guess I don't have such ambition, but it does exist. And actually, a point just to raise is actually one like Pam Carlin, who I know Ed vociferously opposes in many respects, but I want to give one quote from her. So Pam Carlin is a very prominent professor at Stanford, very liberal, openly. I mean, she has no inhibitions about her politics and her beliefs. She was not considered for an Article III position. Ed would have flipped his lid if she was. But someone asked her, would you like to be on the Supreme Court? And her answer was instructive. She said, let me read her quote, "You bet I would, but not enough to have trimmed my sails for half a lifetime. In a lawyer, courage is a muscle. You develop courage by exercising it. Sitting on the fence is not practice for standing up. Imagine what it takes to live your entire life trying to not piss people off and do very middle of the road. That becomes your second nature." John Roberts. And also, this town, Washington, D.C., where Ed lives and I went to law school, has a way of affecting people in perhaps pernicious ways. So we need someone who can resist the influence. This was Glenn Beck's chiding of the Chief Justice in 2012. Or, as I put it, we need less John Marshall and more James Madison. John Marshall should not be an icon. He made stuff up where there was no standing. I mean, he made stuff up. There's a reason why John Roberts venerates him so much. I don't think it's a good model. Okay. Third, this is probably where Ed and I would disagree the most. We agree on a lot, but here's the part we're going to disagree on the most. I think we need to reject these calls for judicial restraint. And I'll let Ed describe more what I mean by judicial activism and judicial restraint. But I want to focus on this idea that judges should not be activists. They should not be activist judges. I don't like terminology, and perhaps more than maybe Clark Neely or Randy Barnett. I don't particularly care for what activist is. I don't care for what restraint is. I don't care for what engage is. The labels don't do much for me. What matters is what judges actually do. And I want to use an example from my first book about the Affordable Care Act, Unprecedented, which they mentioned earlier. So there were two nominations. There were two Bush nominees in that case. There was John Roberts and Sam Alito. They're both well-respected jurists. Apparently one was a Federalist Society member, the other maybe wasn't. But they had a choice to make in that case, okay, NFIB v. Sebelius. They both agreed that individual mandate was compelling people to engage in commerce. They both agreed that it was indeed unprecedented and unconstitutional for Congress to compel someone to engage in commerce. They both agreed with that. Where they broke off is what happens at the end of the story, right? Justice Alito said, well, this thing's unconstitutional. Scrap it. Void. Chief Justice Roberts said, well, it's unconstitutional, but as a judge, if I can find some way of saving it, some way of twisting over backwards, and then rewriting a tax as a penalty, and a penalty as a tax, and this saving construction, and that saving construction. State means federal, and you get the picture, right? I will do so. Had John Roberts actually been committed to judicial restraint, his opinion would have been very short. All it would have said was, this can be construed as a tax, end of the day. But he did more than that. He wrote this entire 30-page opinion about the Commerce Clause that was absolutely and utterly irrelevant to his case. It didn't matter, right? The Commerce Clause was irrelevant to the case. He was trying to be John Marshall, right? Rule for the government, but set a principle for later. What is this, right? Go with your gut, right? Don't slice up the Affordable Care Act. You're not an umpire. You're throwing curveballs, okay? So in the end, okay, ooh, it crashed. Ooh, my presentation crashed. That's a first during my talk. I can wing it. So in the end, right, we need umpires who are calling balls and strikes. We need umpires who actually are sticking with their view of the Constitution. So how do we actually check this, right? How do we actually verify? How much time do I have left? Really? Wow. I'm good on time.
I have 2 minutes.
I think I have 2 minutes left. I think, yeah, I didn't think so. Okay. I've been my okay. As I wish, yeah. So where was that? Okay. Here, I'll start from here. So the fourth lesson, and I'll finish the time, I promise. The fourth. Okay. The fourth lesson that I want to discuss is how do we actually identify the proper candidates? Okay. How do we actually identify the proper candidates for the judgeship? So the fourth lesson, as I get to the slide, is that we need to focus. Here we go. We need to focus on the Constitution as a whole and not issues du jour. Okay. It's very often that as Supreme Court nominee we ask, what do you think about this issue? And the big issue now is Citizens United, right? Hillary Clinton and Bernie Sanders have said we need a Citizens United litmus test, right? We need will a judge vote over Citizens United? I mean, that's an awful thing to actually have a judge prejudge. But the right does the same. What does the judge think about, Bush v. Gore? What does the judge think about Guantanamo? What does the judge think about Berkeley, right? What do they think about Obamacare? Focusing on issues is very short-sighted. Oh, and by the way, I'll put gay marriage there. I don't want a litmus test, and maybe Ed might disagree. I don't want judges to be asked, do you agree with the Berkeley? I don't think that's a productive question. Dred Scott, whatever. Let's move on a little bit from that. But we should not be focusing on the questions of the day. We really shouldn't. There are much bigger pictures. We don't know what constitutional black swans will appear in 20 years, right? When Bush v. Gore happened, could anyone think that would have happened? When Guantanamo happened, that was unpredictable. The final lesson I'll wrap up here is we should focus on clauses and not cases. And let me explain what I mean by this. If you ask a justice, what do you think of the Second Amendment? They'll say, well, I think District of Columbia settled law. That's what Sotomayor said. District of Columbia v. Heller was settled law. 1 year later, McDonald should basically ignore Heller. But she said that's settled law. What do you was Heller right or wrong? Oh, I can't answer that. Fine. So you ask a justice, what's your understanding of the original meaning of the Second Amendment? How was the Equal Protection Clause originally understood? These are questions judges can answer. These are actually questions which are of relevance that they can't dodge. I think it would also go a long way to demonstrating a judge's legal acumen. They actually know history, or they're merely parroting precedent. Because frankly, once you're on the Supreme Court, precedent doesn't matter anymore. So these are 5 tips for selecting the next justice. I went through this quicker than I like. Hopefully between Ed and Bertrall, we'll have more time for discussion later. Thank you so much. Am I on time? Good? All right, thank you, Ed. Yeah, of course, sure.
Thanks very much, Josh. Thanks to all of you for being here. Thank you, Professor Ross. I'm going to, I thank Josh for his interesting, provocative discussion. I'm going to, I think, the last half of my comments indicate some areas of disagreement, but I'm going to start by addressing what I think is a basic omission in his presentation, or at least some fuller context that I think needs to be factored in at every step of the process. And that really concerns focusing on the role of the Senate. Josh mentioned what happened with Judge Bork. He didn't mention the key fact, which explains what happened to Judge Bork. which is that in 1986, the Democrats won control of the Senate. Judge Bork was facing a Senate that was under Democratic control. That is the dominant reason he was not confirmed. We talk about the 2016 elections. The presidential election is obviously very, very important, but the Senate elections, when it comes to nomination and confirmation of Supreme Court justices, is at least as important. The current Senate, as you know, is divided 55 to 45, Republicans to Democrats. But there are lots of Republican senators up in November. Indeed, 24 of the 34 races are in seats currently held by Republicans. And sophisticated political forecasters see this as see control of the Senate as very much up for grabs. Obviously, it's a long way off. Lots of things can happen. You can paint different scenarios. But right now, it appears to be a very close question whether the Democrats or the Republicans will control the Senate beginning in 2017. And that is a hugely important question when it comes to Supreme Court confirmations. There's been a lot of talk about these contentious Supreme Court battles that we have. And one fact I'd like to emphasize is that it hasn't been since the Justice Thomas confirmation hearing that you have had a president of one party making a nomination to the Supreme Court to be confirmed by a Senate controlled by the other party. That is exactly the configuration that most ignites conflict. That's where you got the greatest potential for controversy. That's where you have the prospect, as Josh mentioned, of a seat remaining empty for a while. And that might well be the prospect that we have in 2017. Obviously, a good presidential candidate may have coattails. A bad presidential candidate who, I don't know, might still win, but could alienate a lot of voters in states, and it could be headwinds for same party nominees. Let me discuss a bit just why it is that the Senate matters. The most obvious reason, of course, is that you need a majority approval of the nominee. As Josh said, 50 plus the vice president to cast the tie-breaking vote. But the margin of control also matters a lot. If you have a mere 50 of your party in the Senate, you have no margin for error. You have to worry, if you're Republicans, about some of your squishy moderates jumping ship or being lured astray. And likewise, the Democrats, if they have 50 seats, they have to worry, will they keep Joe Manchin, for example, the West Virginia senator, if they make a wild pick. This has effects not only on the confirmation process, but on the nomination at the outset. Because as much as we would like Republican presidents to show real courage and think about the long haul, the inevitable political reality is that the short term always has more obvious costs from the White House's perspective. And there's only so much you can fight there. You can encourage people, yes, think about the long term, this will be to your credit. But Barack Obama, for example, doesn't much care what happens 20 years from now. If Elena Kagan were to go south 20 years from now, she's already delivered for him. It simply doesn't matter much to him what happens 20 years from now. Now, what majority control also means, of course, is that you have majority control of the Judiciary Committee, which is very important for procedural rules, managing the timing of the hearing, something that was done to Judge Bork's detriment back in 1987, managing the timing of the vote, all sorts of procedural maneuvers that you can make that have an impact. And of course, majority control also means that you have the ability to abolish or retain the filibuster. I entirely agree with Josh that there's every reason to expect that the next time Democrats believe they need to abolish the filibuster for Supreme Court nominees, they will do so very quickly. The only reason they didn't do so back in November 2013 is Planned Parenthood and the other pro-abortion groups said, no, don't do this. It'll make it easier for the bad guys to confirm nominees who are anti-Roe. That was the reason why Supreme Court justices were not folded into the abolition of the filibuster for lower court nominees and executive branch nominees. So the New York Times has has reported. Now, you can think about the different configurations of same party president and opposite party Senate, or same party Senate. When it comes to the filibuster, let's just take a specific example. Let's assume you have a Republican president in 2017, and you have a Democratic Senate, Democratic-controlled Senate, maybe a tiny margin. The Democrats are going to think, of course, we're going to let this filibuster rule remain in effect. That way, we can rely on our strongest 41 senators to block confirmation and not have to worry that we might lose 2 or 3 and give the Republicans a majority. So just one illustration of how important it is to have that majority control. Let's see. I want to offer you what I think is an insightful model of the senator's behavior. I think it's a way of understanding how the process has changed over time, also of understanding, how is it that 20 years ago people got so, that Ruth Bader Ginsburg and Justice Breyer got confirmed so easily. And when I attempt to present it, I call this my public choice model of senator's behavior, a model that looks to the individual incentives that senators face in conducting themselves on Supreme Court nominations. And my hypothetical senator here, I will call Senator Smiley. Senator Smiley walks up and down the halls all day, waving at everyone who walks by. And he's been in the Senate long enough, usually takes about a year or two, to figure out that the big question on every single matter he addresses, the thing he needs to ask himself is, what's in the public interest? No, that's a joke. Is what is in Senator Smiley's self-interest? What will help him not only get reelected, but get reelected easily? What will make it so he does not even face a serious competitor? And part of the answer to that, Senator Smiley figured out long ago, is to avoid controversy. And what better way to avoid controversy? I think Republican senators determined some decades ago, and Democratic senators did too until the Bork nomination. What better way but to lie low on Supreme Court nominations, get credit for moderation by supporting a nominee from the other side of the aisle, invoke this high-minded principle of deference to the president as to give yourself cover to explain why you're doing what you're doing. Say that the only question should be, is the nominee qualified, and pretend that that question somehow could be divorced from fundamental issues of judicial philosophy, constitutional interpretation, as though it's meaningful to ask, is this person qualified, without knowing what they think about constitutional interpretation. Okay, someone was a very talented lawyer, someone as a lower court judge, did a decent job when he or she was bound by precedent. What does that say in and of itself about whether a person is qualified to be a Supreme Court justice? Very little, I would say. Back decades ago, before the internet exploded things, the nomination process, the confirmation process could be a very inside game, where the ugliest aspects of a nominee's record that would come out weeks after the nomination could be kept undercover. Best example I have from that, Justice Ginsburg. I was the lead Republican staffer during the Ginsburg and Breyer nominations. Justice Ginsburg, it was discovered weeks into the process, it was discovered by me, not sure by anyone else, had co-authored in 1976, I believe, a document called something like Report on Gender Bias in the U.S. Code. I don't have the title exactly right. I've blogged about this. You can find it, and the entire document is available on my institution's website, since a lot of people said, oh, surely she couldn't have said things as crazy as this. We said, well, yes, she did. And in this document, Justice Ginsburg took the position that prisons should be co-ed, because after all, what better time for men and women to learn to get along? That the Boy Scouts and Girl Scouts should be blended, should be encouraged to become a single androgynous Scouts organization. That Mother's Day and Father's Day should be abolished, and in favor of some sort of Parents' Day. I'm forgetting another great one. It's the sort of thing that, frankly, these days, as soon as someone would be floated as a possible nominee, this would come out, and the person would be a butt of jokes for a while. That that document was never discussed publicly. There's not a single question asked about it at the hearing. There's one article, I think, in the entire country written about this, I think by Phyllis Schlafly, that otherwise got no attention. It was an inside game that was able to be managed back then. And the purpose of Senate hearings, sometimes people watch senators ask questions and wonder, well, why didn't they do any follow-up, or what's the purpose of this question? Well, under the old model, where senators thought they could make this whole process uncontroversial, you don't want to get answers to your questions. You don't want you want to be up there asking questions about as Senator Pressler did in two straight confirmation hearings, asking obscure questions of Indian law that Senator Pressler plainly didn't understand, the nominee plainly didn't understand, didn't even try to answer. But because this shows well in South Dakota, saying Senator Pressler is asking these important questions about Indian law. So there's a lot of a big show. Now things have changed dramatically since the Ginsburg and Breyer hearings. They changed for the Democrats before then with Judge Bork. Basically, you had the political base of the Democratic Party drive Senate Democrats out of their old mode and force them to fight on judicial philosophy. The same thing has finally happened with Republicans. The sharp contrast, even though the bottom line results were the same, between how Republicans approached the Ginsburg and Breyer nominations made by President Clinton and the Sotomayor and Kagan nominations made 16 years later by President Obama. There were, I believe, 31 and 38 negative votes against Sotomayor and Kagan. There were 3 and 9 votes against Kagan and Breyer, and several of the 9.
Ginsburg and Breyer.
I'm sorry. Thank you. Ginsburg and Breyer. And several of the 9 were votes against Breyer were votes from the left. I think Howard Metzenbaum and others voted against him because they thought he had too close ties to insurance interests. Okay. I'd like to turn now. I'm going to make sure I stay with him in time too, so Josh and I can have a discussion to explain some of the areas in which I disagree with Josh's proposed guidance. Look, I think there's a lot of good wisdom there. I think there's a lot of hopeful advice. Some of the advice I think is a little politically naive. It reminds me a bit of the old joke about I think it's a physicist, the chemist, and the economist who find themselves on a stranded island with cans of food but nothing to open them with. The physicist and chemist devise ingenious solutions, and the economist just says, "Assume a can opener." And I think Josh may too readily, assume confirmation in some cases where it's just not going to be possible. So yes, absolutely, bruising confirmation battles are worth the political capital, but you don't make that pitch to the White House political people because their first instinct would say, "Oh, no, it's not." You need to figure out how to frame things to make sure it's worth it to them in the short term. You've got to make them understand that they're going to pay a price if they stick with a bad nomination. That's what happened with Harriet Miers back in 2005. The second lesson Josh has drawn is that paper trails are an asset, not a disqualification. I partly disagree. I partly agree, partly disagree. Yes, it'd be great to have a good paper trail that gives insight into how someone thinks. But obviously, a paper trail can also provide serious ammunition to the opposition. And depending on the configuration in the Senate, it may make it very difficult to get someone confirmed. So it depends what the paper trail is. It depends on the circumstances. On judicial restraint, I disagree with Josh both on substance and on political tactics here. I'm sorry, it's one of these waters I can drink. Voice here. What the heck? Safe here, right? One reason why there has been talk of judicial restraint is because it's been politically effective, and you don't give up something that helps you get nominees confirmed if you don't have some sort of plan that's going to be as effective. Now, look, I don't think judicial restraint is the be-all and end-all of the judicial role. It's an important part of it, but I think what one needs to do is define as the first principle originalist constitutional interpretation, And then where the Constitution fails to yield a sufficiently clear answer to a constitutional question, that's where judicial restraint kicks in. Conversely, it's important to enforce the rights that actually are in the Constitution. And it's no coincidence that the same liberal judicial activists who invent rights that aren't in the Constitution will ignore those rights that are. So I think there's a great possibility to make a case politically for coherent constitutional interpretation. And judicial restraint will be an important part of that. And I'm sorry to see that many in Josh's libertarian camp, I don't know if this is true of Josh himself, but their opposition to talk of judicial restraint seems to be because they really like judicial activism. And they really hope somehow for some sort of new era of libertarian judicial activism, an era that seems highly improbable given that there's not a single justice on the Supreme Court who has shown any sort of broad embrace of the libertarian constitutional agenda. I think the part of Josh's presentation and his article that I most disagree with, though, is the mantra, focus on the Constitution, not issues du jour. What better way to understand what someone means by a professed adherence to originalism than to see whether he or she believes that Roe versus Wade or Obergefell was rightly decided. If someone could write 10,000 articles on originalism, but that person believes that Obergefell was rightly decided, in my judgment, that person is not and cannot be taken seriously as an originalist. And you bet, I think that ought to be disqualifying. And I don't quite understand how Josh connects his earlier discussion of paper trail and trying to really understand these nominees and looking for someone with courage, for example. What better sign of courage than standing up, for example, on Obergefell, saying whatever your policy views are on same-sex marriage, that is a matter for the democratic process, not something the Constitution speaks to. I believe John Yoo, for example, has taken exactly that position while supporting, I believe, same-sex marriage as a policy matter. So many people, including I've seen so many in the libertarian camp, years ago seemed to be quiet when everyone recognized that the constitutional argument for same-sex marriage was ridiculous. And then suddenly, as the political tides turned and judges began adopting this ridiculous argument, they embraced it. Is that courage? Is that clarity? What sort of originalism is that? What does that mean down the road if you actually care about how issues are going to be decided? So I think there's a serious disconnect between in the proposition focus on the Constitution, not issues du jour. I think you can actually understand a great deal about a person's approach to the Constitution by looking at his or her approach to the issues that have arisen. Now, let me be clear. What you need here is a divide between constitutional views and policy views. That's a divide that has largely collapsed in our legal culture. Maybe it's impossible to restore it. Maybe all this talk about trying to get serious originalists, maybe we should all just. In many ways, I'd be more comfortable with the libertarian claim if there's some who say, "Hey, we're not originalists. We just want to advance the libertarian conception of liberty." Well, to me, they get credit for candor, and maybe that's better than what seem to be the mistaken claims that some libertarian originalists make on behalf of their positions. So Josh's fifth point, focus on clauses, not cases. Look, you're not going to get anything more out of a nominee by saying, please explain the Second Amendment to me than saying, do you think Heller was right? Those are, for starters, those are just different ways of asking the same question. Secondly, the same senators who don't do follow-up and can't ask probing questions are not going to be able to deal with nominees who choose to duck those. So I just don't think there's much that you can really achieve that way. Look, the confirmation process over the last several decades has yielded very, very disappointing results. A lot of that, as Josh correctly points out, is because of the weak nominations the presidents have made. Big mistake by the sainted Ronald Reagan. This one doesn't get as much attention as it ought to, in picking Sandra Day O'Connor back in 1981 when there were, I believe, 58 Republican senators. a huge blown opportunity. My understanding is he went to the Justice Department and said, hey, during my campaign, I said I wanted one of my first nominees to be a woman. Find a female nominee. Justice Department looked hard, came back, said, sorry, we can't find anyone who's qualified. We'll look again, and came up with Justice O'Connor, who, what was her position at the time? She was a intermediate state appellate court judge. I forget how many years, but there's nothing in her record to indicate that she was going to be an excellent justice. And you know, I think well, we saw what played out. Reagan ended up batting 1 for 3 or 2 for 4. Josh, you know, mentioned Anthony Kennedy. That, though, again, is an example where the White House was just exhausted because the Democratic control of the Senate forced them, they thought, to resort to Plan C. You look at the Souter nomination. That was just the White House fooled itself into thinking that it had someone who was a serious originalist, apparently because David Souter had been able to talk intelligently about originalism in his interview for the First Circuit seat. They didn't realize that the ability to talk intelligently about it did not mean that he agreed at all with it. And of course, you know, we have the Harriet Miers debacle. So look, there are no guarantees going forward. If you want to get a really good series of nominees, which we very much need, obviously first elected president for whom this is a priority. That is not Donald Trump, and if anyone, you know,
Judge Judy for SCOTUS.
I mean, Donald Trump is as likely to nominate Hillary or some Hillary clone as he is to make a good nomination. Just be a disastrous approach to things. I think there are other presidential candidates who put more hope in, but you cannot trust anyone to do this right. You need to make sure that the White House is staffed at the most senior levels with people who give this issue priority, the right people in the Justice Department, and the political pressure needs to be put on from the outset. You need to have good candidates prepared, vetted by outside groups, and as I said before, you need to keep the Senate in Republican control, because if that doesn't happen, it's going to be very, very difficult to get anyone through. Look, I think I've been talking long enough here. I think invite Professor Ross to offer some comments, then Josh and I will mix it up with you in Q&A. Okay, thank you.
Thank you, Ed. And that's my water. You're clean. Okay. Uh-oh. You might get some libertarian toxins, though. I don't know. You might. If he starts talking about Lochner later, we know why.
So I won't take up too much of the time because I want you guys to have a lot to engage Ed and Josh with. But I just want to, I kind of wanted to frame the discussion. It seems to be a discussion about courage versus moderation. And when are the opportunities for courage available? And I think that an important point that was raised with respect to the courage versus moderation debate is that courage can happen under pretty strictly confined conditions. Courage can happen when you have a president who is willing to go to bat and expend political capital on judicial nominees, that they have a Senate that is aligned with those preferences, preferably a Senate that comprises of close to filibuster-proof Republican majority, and the political pressure from on the ground isn't great enough to stop those nominees. Now, I think that those are unique circumstances that happen once in a lifetime and perhaps once in every 2 lifetimes. And I think that it's unlikely that a president is going to want to expend the political capital because they are going to be short-term focused. I don't think the president thinks that necessarily they want their legacy to be simply judicial nominees. They have other things they want to include in their legacy, other types of policy reforms that they're thinking about. And even if you sort of declare the nuclear option with respect to nominees for justices, there is other parts of your agenda that can be stopped if you decide to go nuclear with respect to judicial nominees. And unless you're going to go nuclear across the whole legislative program or legislative process in the Senate, there are ways to clog the agenda that in a way that the president might not like. So there are other sort of agenda backlash effects that may limit the courage of a president going forward. Now, one thing I was interested in terms of seeing in Josh's talk, he framed this as primarily a Republican problem. Now, it may be the fact that mostly Republicans are nominating justices over the last 40 or so years, But one thing I was thinking about is there something about the conservative vision of the Constitution that is vulnerable to evolutions and shifts to the left? Is it politically untenable for a court concerned about its political legitimacy to advance this constitutional vision as a member of the Supreme Court? Another thing I started to think about in terms of exercising courage, who is the conservative Pam Carlin from which Republicans and conservatives might draw? Can it be found in today's this generation of jurists who have been careful in terms of what they do in thinking about their nomination in the future? It is perhaps foolhardy to think that people will not think about their ambition in terms of what they do in their lives. They may not be a Pam Carlin willing to restrict what they do in order to advance their goals for the future. And a final point with respect to courage and moderation before opening this up is I think that it is important to think about the role of the Senate. Even if the president is the one that is willing to take capital, senators thinking in terms of a rational choice calculation about re-election is my primary goal, may not go along with the president, may push the president to go in the direction of moderation. Because re-election hopes, as it has properly put, are threatened by controversy. And if you can avoid controversy with uncontroversial nominees that push you towards or tend to be more moderate, right? And you're advancing your re-election goal, well, maybe you will encourage the president not to be courageous with their particular nominees, right? So there may be just a party apparatus that limits courage. And so as we go forward, right, I think that moderation is a likely course for the future, whether it's a president on the right, a Republican president or a Democratic president. It has been the path that has been taken over the last 50 years. President Nixon was another president that tried to push two quite conservative nominees before having to go more moderate with the nomination of Justice Powell, before the nomination of Justice Powell, who ended up being center right. And there's also, of course, the President Reagan and Reagan and Bush nominees that have been discussed during this talk. But I think it opens up a lot of interesting issues, and I think that it's important to engage. And I'll keep the cue in terms of who wants to engage in this conversation. So thank you all for taking part. And I think the first question, Susan, let's have the first question. If you raise your hand after the question, I'll call on folks.
Yes.
So this is for Ed Whelan. I'm not a lawyer, so I don't really know this. I think the one thing I agree with you on is that Senate hearings, the confirmation hearings, are just basically grandstanding for their local audience. But I want to mention something. One of our former law professors here is now on the California Supreme Court. He's known as a liberal, but he's open to conservative views, clearly in the mainstream. This has been pointed out by his rulings on the court. I see you're smiling because I know you know who I'm talking about. And his name is Goodwin Liu. And in 2010, Obama nominated him to the Ninth Circuit Court of Appeals. And despite staunch Republican support from Bush's chief White House ethics lawyer, Richard Painter, and Ken Starr, the former White Water prosecutor, and a number of our own conservative law professors here, you did everything you could to block his nomination. And now when you look at his rulings on the California Supreme Court, you can see that he really is in the legal mainstream. He's not an extremist or radical, as you called him. And I'm just wondering, for the benefit of the students here, and for all of us, how this sort of partisanship is really helping our democracy. I don't see that it is, because you called for a really strong battle. And I can see that these battles become so polarized.
I think I have the question. Thank you. I did not do everything in my power to stop Goodwin Liu. What I did is I examined his record and I spelled out item by item in a way that no one could dispute the radical aspects of that record. And I invite anyone here to look up what I wrote and look up some of the lousy claims that were made on his behalf. Back then, people were pretending, for example, that he didn't support same-sex marriage. Back then that was something that the left viewed as beyond the bounds. There are a whole host of things in his record. I'm not coming here to debate Goodwin Liu. I don't have in mind everything about it, but I know quotas, a whole host of other things he's called for putting Supreme Court precedents in the dustbin of history. There's a whole lot there that I think clearly marked him as an extremist, a very bright extremist. I had never questioned his intellect. Indeed, I praised his intellect. He's a very deft writer. He, I think, was all of 38 years old when he was nominated. I don't believe, for example, my final point here, that his record on the California Supreme Court somehow shows that I was mistaken. I mean, show me one contentious case there where he where there's a divide on the court. This is a very liberal court. After all, this is the same court that that struck down the California's definition of marriage way back in 2008. So I think the whole premise of your question with respect is wrong, and I stand by every jot and tittle of my criticism of Goodwin Liu back in, whatever it was, 2009 or 2010.
Okay, another question.
Thank you very much for Josh and Professor Ross. Thank you for your point about I really like the backlash about presidents having multiple items on. I was wondering what you think about it in terms of, I'm thinking about Nixon. Nixon ran his political campaign for president exclusive, not exclusive, but a large part of it he ran against the Warren Court. He says, I'm here to, and he made the federal judiciary point of contention in his run for the president. He said, when I come in, I'm going to point law and order judges. And so in that sense, like, making your campaign so contingent on the way that you're going to reform the federal courts, maybe the Supreme Court seems to provide a way forward to prevent a lot of these political backlash, or to unify what an administration of many different things it wants to cover into one thing. And I was thinking, what do you think would be, what political moment would that require for a Republican or a Republican president in the sense? Because in the 1960s, it was warrant and criminal procedure reforms coupled with increasing crime. That was a big thing. It wasn't just the warrant reform, but all those put together created this political moment that allowed Nixon to appoint, I think, a number of conservatives. Berger,
So yes, so I appreciate the question. I also appreciate you to respond to a few of Ed's points. Nixon, for sure, wanted law and order conservatives. He wasn't concerned about much other than that. And I think he actually got law and order conservatives. I mean, Berger and Blackman, whatever, over their failings, they were pretty much on board with respect to that. But I think that's sort of issue du jour problem. And let me respond a little bit to Ed's claim. I'm not opposed to originalists. In fact, I want originalists on the court. I think that's a valid and rational method of interpreting the Constitution. I am more interested in a person's commitment to originalism than how they see a specific issue. And to use an example, this has been reported, and I injected Michael McConnell's name, but it's been reported that when President Bush 43 was considering a replacement for the Roberts seat and then the O'Connor seat, he wanted to say, how will this person vote on the war on terror? How will this person vote on Guantanamo cases? For him, that was the biggest issue, right? Will they uphold my entire war on terror? Yeah, he got John Roberts. And John Roberts, a couple of days before he was nominated, wrote this great Guantanamo decision in the D.C. Circuit, which was pushed out right on time. But there was perhaps less of a focus on broader things. Now, I said Michael McConnell's name. He is a scholar of the high circuit. He might be a liberal Pam Carlin, who will never be on the high court. Although he did make the 10th Circuit. But I think his framework, I think, is something that would have been very beneficial. I don't pretend, I mean, I talked with John about this minutes ago. If Michael McConnell was in the Supreme Court, I don't pretend for a second we'd have Obamacare anymore. John, am I right? Anyway, if Michael was in the Supreme Court, I don't pretend for a second we would still have Obamacare. I think he would have voted as Justice Alito did and as Justice Scalia. But the framework, rather than specific issues, I think is a danger. In fact, one issue Nixon wanted, this is bizarre, he wanted geographic diversity. He wanted justice from different parts of the country. Right, he wants someone from Virginia to pick Lewis Powell. Can you imagine picking a justice based on where they're from? It's almost unconscionable that you can make a decision with that in mind. But that was, I think, Nixon considered.
Well, geographic diversity had long been a consideration for presidents, and it's just part of the political reality of getting someone through the Senate. I mean, for all of his, what might have been his talk of geographic diversity, ended up with 2 justices from Minnesota. So I don't think he gave it all that much weight. Obviously, we don't have much geographic diversity on the Supreme Court right now.
We have 4 of the 5 boroughs, and I'm from Staten Island, so I will. Sorry.
That's okay. Further questions?
This is for Professor Blackman. I was wondering what you meant by you want that the Chief Justice should follow his gut more, and if it's to be understood as people commonly understand that, do you see that as a judicial philosophy at all?
Well, so the judicial philosophy of the Chief Justice, I think we saw at NFIB and in King v. Burwell, is I think he's focused more on the Supreme Court as an institution than the Constitution itself. I think he's more scared about what people will criticize the court than how he actually rules and follows the Constitution. And I think there's a significant cost to that because liberals realize that works, right? So there was a campaign in NFIB to influence his vote. And well, if you read my book, I think it may have actually had some impact. In King v. Burwell, the Obamacare decision a couple of months ago, there was a similar campaign saying that Mr. Chief Justice, don't do this. All these people will lose their Obamacare subsidies and they'll be worse off. Okay, well, the Chief Justice voted the way he did. I think when you allow yourself to be goaded by this institutional concern, people on the left can take advantage of it. And the more you allow it, the more they'll do this. And it's almost like a self-perpetuating cycle. Ed, do you have anything to add?
Well, one observation, not necessarily agreeing with everything there, but we have the weird convention of referring to the court by the name of whoever happens to be the Chief Justice at a particular time, no matter whether the rest of the court changes under him. So we talk about the Burger Court, the Rehnquist Court, and the Roberts Court, even though what we've really had for the last 25 years, as for all practical matters, been the Kennedy Court. I think there's a danger that in referring to the court by the name of the Chief Justice, that we sort of encourage the Chief Justice to think in institutional terms, as though what happens when he is Chief Justice is really part of his legacy and responsibility, and he's really one of 9 votes. I think it also just leads to lots of confusion, as people can think that what's this crazy Roberts Court that's doing all these other things that we think are nuts, and not realizing again that on most of these matters the Chief Justice is not the critical 5th vote.
Mm-hmm.
I'll ask a follow-up. So essentially, when you say follow his gut, you wanted to follow the Constitution.
Yes, I want judges to follow the. Yes,
Correct. So
that's a correct statement.
Why don't we just say that instead of follow your gut? Because I think for a judge to follow.
Oh, okay. And then maybe I didn't use my language clearly enough. If the judge thinks that this act is unconstitutional, he should not be goaded to rule differently based on concern of what happens afterwards. I think I more clearly articulated it that way.
Other questions?
Nothing else there? Well, Josh, did you? Oh, Sohan?
I had a question. Josh touched upon it in his article, but Ed, if you could, and Professor Ross, if you could mention, tick off several attributes that you would like your ideal nominee to have. You don't have to take names. You don't have to use names, but of persons, but several attributes that you would like your nominees to have.
Well, I think for starters that extensive judicial experience is a plus. I don't like the idea that we're going to get a senator, say, as a nominee. I think that the very notion that someone could easily move from the role of a senator into that of a justice reflects the confusion between law and politics that we have these days. Now, it's true, of course, that we had senators in the past who made that move, but I think that was in a culture that reinforced the distinction between law and politics. Now, one challenge in looking for a lower court judge, a federal court judge, is that judge is operating in a system where he or she generally views higher court precedent as binding. So you don't necessarily know, for example, if you have a Commerce Clause case and what it says about the jurist's own view. By contrast, if you have someone who's been operating in the state court system, a state Supreme Court justice, addressing questions of federal constitutional law, you may have some opportunities for that. Though frankly, and this goes back a little bit earlier to the question about Goodwin and Liu, what I hear in so many state Supreme Courts, the questions they're dealing with these days are so boring. You're just not going to get you know, a very good sampling there either. So look, I'd like someone who's very sharp, whose quality counts in the confirmation process. You want someone with stellar credentials, and you know, ideally someone who could sit on the bench for decades. It's hard to say in the abstract. That's been a rather empty answer. Obviously, I'm looking for a commitment to originalism and judicial restraint. There's always going to be guesswork involved here. You're never going to have a really firm read on how someone's going to turn out, precisely because the issues you see down the road, you know, aren't ones that you're thinking about much now. So I think, unfortunately, we're left with an element of crapshoot in our picks.
Yeah. Mr. Ross, do you have anything you want to answer?
Oh, you guys were
I have two words.
Jeez.
Justice Obama. Hillary Clinton has said in recent weeks that she would consider appointing ex-President Obama to the U.S. Supreme Court. Ed, you can start drafting your 1,800-part series of why that should not happen.
Yeah.
There's a question in the back?
Yeah, I mean, I think it's sort of funny, and you just said you want somebody with a lot of judicial experience, somebody who could sit on the bench for decades, right? Those are qualities that are probably mutually exclusive.
Well, they're not really. I mean, you get someone who's say appointed. I mean, look,
what's the magic age? What's our range?
You have a number of Bush 43 nominees, appointees rather, to the lower courts, who have been federal circuit judges for a dozen or so years now. That's plenty. That's plenty, and who are still in their mid-50s. So that I view that as sort of prime territory.
Fair enough. This is preparatory.
Okay.
My real question
A well-regulated? No, never mind.
I think you guys both shot from the hip and criticized an awful lot of people. I think some of them probably unfairly. So I'd like both of you to do what Sohan asked you not to do, and to name names and to say not only who you would like to see as conservative judicial nominees beyond Mike McConnell, but also if you could place yourselves behind the veil of ignorance, as it were, because I know we have some liberal friends in the room, and think as liberals and see who you would like to see them as courageous liberal nominees. Could you go through that?
Well, first I want to, you made a charge here. I'm not sure what it's based on, that we've been taking shots at people. I don't know.
I think the asides about Chief Justice of the United States, about Justice Souter, among others, were a bit gratuitous. That may be a matter of taste.
So I guess he's aiming at you, Josh. But
I mean, I wrote an entire book in the Court will care about case you want to see. I think all my charges in the Chief Justice are pretty well backed up. Justice Souter's 25-year record in the court as a fairly consistent liberal, I think I can back up all of those charges.
A lot of guests have made some very valid points here and outside as well.
But on your question, I mean, let me answer your question. If we still have a couple minutes. Look, you can look at in terms of Republican candidates, you can pretty much look at any federal court of appeals and see someone who fits the description I'm talking about, whether it's Brett Kavanaugh or Jeff Sutton or Steve Colleton or Neil Gorsuch, Bill Pryor. I'm probably leaving out some people. You can look at Solicitor General Paul Clement, who doesn't have a judicial record, but obviously has a long history of thinking very seriously about constitutional questions. On the trying to put myself behind the veil of ignorance on the Democratic side. I mean, if you believe that constitutional law is whatever you want it to be, what are you doing? You want to get someone who you have confidence will live for as long as possible, and who knows what else. I find it's a intellectual game of no content to try to figure out what you'd want from someone on the Democratic side, except someone who will entrench her views when she feels strongly enough about it.
I'm not going to name names.
Appreciate the question. How do you feel about that?
Term limits? Well, it's I mean, I guess there's some clever statutory scheme that suggests you might be able to do this without constitutional amendments. But look, there are not process answers to our problems. We need. I don't think. Yesterday, some countries, I think India and Thailand, have maybe I'm remembering the wrong countries, but have Supreme Courts that consist of hundreds of members. and I actually was thinking that could sound pretty good.
Are they randomly drawn or a panel, or has it?
I think they generally have. Yeah. So I don't know. I think of the court of the last few decades has done enough to destroy the Supreme Court as a constitution interpreting institution. I don't quite know where we go from here, but I don't think there are any process answers.
And don't you think that term limits might politicize the court even more, because then we would know when a vacancy is coming up, and that's gonna, affect elections around and all that?
Well, they might. The answer that proponents give is that, on the contrary, the stakes are so big right now because we don't know that there'll be these seats coming up in the future. We think this one is the one that might decide everything forever. Undoubtedly, there'll be unforeseen consequences, but again, the fact that it's will never happen is reason for me not to give it too much thought.
All right, we'll give Ed the last word. Mr. Ross, anything?
No, that's it. Great.
Thank you all so much. Appreciate it.
Thank you, sir.
Good to see you.
Good luck with class.
Yeah, thank you.
That was fun.